We are on the record in the Plog matter case D09408-072S. Please confirm your appearances.
Good morning, Your Honor. Michael S. Strange, bar number 9429, appearing unbundled on behalf of the defendant, Haley Plog, who should be present there as well, Your Honor.
Good morning. And the defendant is here?
Yes.
State your name for the record.
Stephen Plog for the plaintiff.
Good morning. This is the time set for hearing. The court, as has previously been noted, the court had deemed the plaintiff to be a vexatious litigant. The plaintiff submitted paperwork, and this court allowed this motion to be set for a couple reasons. I did want to clarify the exchange protocol. That is the focus. I want to be clear for the record. The focus of the motion is to discuss the exchange protocol. I want to restate for the record because we have had prior discussions at length about the exchange protocol. But there are other aspects to the motion that I also wanted to address on the record that was filed. Let me start by swearing both parties in. If you both please raise your right hands to be sworn.
You and each of you do solemnly swear testimony about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and you may be seated. As far as the exchange protocol, I want to deal with that issue first. And for the record, I wanted to restate what the court previously had addressed. It appears that exchange issues have been discussed in the order from the July 19, 2011 hearing, the June 18, 2014 hearing, the January 5, 2015 hearing, the March 31st, 2015 hearing, the May 29, 2015 hearing, and the January 5, 2016 hearing. The most recent order was that from the January 5, 2016 hearing was that the honk and seatbelt rule shall now be referred to as the text and seatbelt rule.
The what?
The text and seatbelt rule.
Text.
That was back in 2016 that the court had clarified that. Parties shall be in communication through Family Wizard. Neither party shall leave their mode of transportation. And that was also reiterated later in the order that you do not leave your mode of transportation.
Can I don't know how to say it. Motion to clarify. When you say text and seatbelt, does that mean you have to wear a seatbelt and you can text, or you can't?
Well, it's a term of art that instead of honking the horn, you send a text saying "I'm here," and then Chase would leave. The idea is that no one leaves their house, no one leaves their vehicle at an exchange. Now keep in mind, this only relates to exchanges when school is not in session. Because when school is in session, in fact, to go on back in May of 2015, this court has gone through, quote, this court has gone through painstaking lengths to ensure that the party's daughter is insulated from the petulance and immaturity of the adults around her. These measures have included the implementation of the honk and seatbelt protocol for non-school custody exchanges, as well as the implementation of a schedule that limits the presence of both parents and other third parties at school exchanges. To this end, this court has relied on tunnel exchanges at school, whereby one parent or a designated representative drops off the child off at school, and the other parent or a designated representative picks the child up at school on those days in which custody is exchanged. This court instituted this protocol to insulate the child from the conflict between the parties, and thus to ensure that the parties or their designated representative are never at the school at the same time. A parent should not be at the school for any purpose at a time in which the other parent is there to drop off or pick up the child pursuant to court order. So that was the May 2015 hearing. The March 31, 2015 hearing, the court is not making any modifications to the honk and seatbelt rule, and the parties are to stay in their car and residence during the exchange. When mom goes to pick up the child from dad, she is to send a message via Our Family Wizard when the child is in her car. So, in summary, there have been 7 occasions in which this court has addressed the protocol for exchanges. So I have addressed it in excruciating detail. Again, going back to what I said, the bottom line is for exchanges when Chase is in school, there's no need for either party to be present. One party drops off in the morning at school and the other party picks up. That way we keep all the adults away from Chase as it pertains to any type of exchanges. And both parties know I've seen enough of what's happened at exchanges to keep all of the adults away from each other at exchanges. The issue that is going to be clarified by the court as it relates to exchanges during when school's not in session. So, for example, right now. And I know the motion the focus is on the TK or the protective order proceedings that the plaintiff has raised in his papers in regards to Mr. Nelson. I want you to understand that for this court's purposes, and this has been raised in the papers, you cannot violate your own protective order. That's a legal fiction in this court. It doesn't happen. If I need to set up exchanges at a police substation, that's something that I don't generally resort to, but if we need to do it there on non-school exchanges, I can certainly entertain that. Apart from that, the protocol has been very rigid in terms of when you show up to pick up Chase at an exchange, no adults leave their vehicles or residences, period. Chase is sent out, you text, you send a message by way of Our Family Wizard, and Chase comes out, enters the car, and there's no interaction between adults because I don't want to, that shouldn't happen. That's the existing order. The question is, does there need to be a change? Do we need to pick a location like a police substation?
I have a simple solution. 2 blocks away from the defendant's house, so it's not too far away, is a mini mart with security cameras. I could just text and say, I'm at the mini mart, and they could drive up.
What are the cross streets?
It's on Twain and Fort Apache, and there's a mini mart and a mobile, I think. Anyway, there's 2 gas stations with cameras. So an exchange would be videotaped and everybody would be on their best behavior.
All right. Mr. Strange?
I'm not there with my client, but I would say, to answer the court's question, first off, I think there's not a need to amend the exchange order based off exactly what the court had just iterated. I mean, if Mr. Plott doesn't want to go to my client's residence, he certainly has the right to send a designated representative under the current order. If for any reason the court's inclined to do it, I would probably, I would ask the court just to make counsel my client. I would believe she would prefer a police substation, just given the history of the case, as well as her own safety and concern, frankly.
Okay. And knowing she's represented by counsel, do you have any objection to the court inquiring of the defendant?
No, Your
In that
Honor.
regard. So, ma'am, what would be your preference? We have, and do you know the location that Mr. Plog is talking about?
I have
terms
an
of this mini
idea
mart?
of the location, but just due to the fact that there's just seems to be all these concerns of safety and such, I would assume just to go ahead and just go for the, the absolute 100% that there's just no sort of question whatsoever or no gray area, and just have it at the police substation. Because then from there can be no question, no what ifs or anything like that. It's just right there. It's in the presence. No he said, she said, and there couldn't be any possible threat with police right there.
Well, let me ask you, do either of you know where the nearest substation is?
Not offhand.
Mr. Plog, do you know?
There is no evidence that I have ever threatened or been violent towards the defendant at all. The honk and seatbelt rule was given on he said, she said. There was never any evidence. There is still no evidence that I have ever been threatened in any way, shape, or form, directly or indirectly, to the defendant, ever. 2 blocks away is a security camera at a gas station. That would suffice. Yes, we could go to a police station. That's not in the best interest of the child. Why am I in a police station for my mom and dad? I just think I don't think it's in the best interest of the child to be in a police station.
Listen.
I think 2 blocks away under security cameras, everybody's safe, everybody's fine, and there is no evidence I've ever threatened in any way, shape, or form the defendant. If
Well,
there is,
listen.
I'll gladly give up 100% custody if you can prove it.
Listen, I've seen enough conflict at exchanges.
No
that-
violence.
Listen, I've seen enough in front of this child, even though it's not physical. There's been enough damage caused to Chase at these exchanges that I don't want this to occur anymore. And if ultimately I'm resorting to having the two of you, I agree. The message you send to a child, mom and dad can't get along well enough. We've got to go to a police station to exchange.
And I hate that.
rarely do that. I don't envision. That's not something I prefer. That's not something, quite frankly, that I think Metro desires to have exchanges taking place. But the bottom line is, I already, as I indicated before, I've gone through excruciating detail to set up a protocol to keep all the adults out of the picture and allow Chase the freedom to just go. To go to school, not have to worry about any drama between the adults, go to school, be dropped off by one parent, picked up by another parent. When we have these exchanges during the summer, basically what I said is no one gets out of cars, no one gets out of houses. So that provides some level. There's no reason you go to the door. You don't. You text, I'm here, she walks out the door. No one says a word to each other. I don't have a problem keeping that. And as I said before, the plaintiff cannot violate his own protective order against anyone else, including a third party, Mr. Nelson. So I don't have a problem keeping it that way. And the sense I get is that the defendant doesn't necessarily have a problem with that, but you must adhere to that protocol in not getting out of your vehicles, not approaching the door. You can't do that. This child's been exposed to way too much. And so the bottom line for me is we either keep it the way it is with that stringent protocol using our family wizard, because it has it's my understanding you can text as well, I'm here, and this is just for the summer months when she's not in school, or the next step for me, given the level of conflict, is we do an exchange you find the nearest substation, we do the exchange there. And it's your motion, Mr. Plug, so I leave it up to you on what you prefer.
Half the summer is gone, and my daughter has been taken away from me a second time by whatever circumstances you want to call it, but it's the second time. Oh, by the way,
You've not shown up for your visitation, for your custody
Can
time.
you say that?
Don't put the blame. You want to point the finger at everyone else. You have not showed up for your custody time. It's time to look in the mirror and
You just told me I
understand.
couldn't violate my own restraining order.
That's a legal fiction. This notion that you can't go to the house and pick up Chase during the summer, there's nothing to that. You're unable. When I say you can't violate your own order, that doesn't mean you can't go pick up your daughter. You can't be. No one can allege you violated your own order. It doesn't work that way. You can go pick up your child at mom's residence under the protocol that's in place. You don't get out of your vehicle. Mom or Nora, and she's responsible for the behavior of other individuals. No one leaves the residence. I have no problem with that. But to start, again, pointing the finger at this court suggesting that somehow you've been denied time because of your own inaction is preposterous. So Chase needs to have her father in her life. And I don't have a problem under the existing protocol. You show up at mom's house, you send her a text via Our Family Wizard, and I noticed that just on July 7th you did renew your subscription. So now you're back on Family Wizard. You weren't before. And so you can do that. That's easier than doing these exchanges anywhere, including a police substation. But for Chase's sake, I've at every level I've tried to insulate her from the drama that I've witnessed for the past 8+ years. And so
in the child's best interest, it's not her fault I didn't go pick her up. Don't punish her. She's seen her mom for 6 weeks. I'd like her to see her dad for 6 weeks. Don't punish her for my mistakes. If we do that, then we don't have to worry about where to drop off, because 6 weeks from now, she's back in
Well,
school
listen,
and all this goes away.
this is not about punishment. I want to institute a protocol, and there's already been a protocol in place. There was nothing that prevented you from showing up at your designated time to pick up your daughter. You should have been there.
Violence.
Well, you don't get out of your car. No one leaves the house. There's been no suggestion by anyone that that protocol, other than what I'm reading, that you're approaching the door, there's been no suggestion that that protocol cannot work or has not worked. You show up, you text, you send a message, I'm here. Chase leaves the residence. No drama, no adults, no words exchanged. And we're done. I have no problem with that.
I'm sorry. I don't mean to interrupt. Because if I don't say it, I forget it. And I'm very nervous and I can't get my thoughts out. I was under the impression that the honking seatbelt rule was a law. I just literally found out 2 days ago, no, it's not a law, it's not in the books. So for clarification, because like a law says, well, if you break it, the punishment is, $1,000 and 1 to 5 years in jail. What is the punishment for breaking the honking seatbelt rule?
It's called contempt. It's a court order. There's no statute regarding honking seatbelt rule. That's a protocol that courts over time have developed to try and insulate children from conflict. I changed the name, as I indicated before.
The motion to qualify, what is the consequences for violating the text?
I changed it, instead of calling it honk and seatbelt, because people don't typically honk their horns anymore, they send a text. And that's easier. So I changed it, and I said, let's call it the text and seatbelt rule. And again, the notion is a parent shows up, sends a text, I'm here, child exit, clicks in, and leaves.
And what is the consequences for breaking that?
The court can entertain an order to show cause.
And what are the consequences of that?
Contempt.
And what does contempt give you?
Monetary sanctions, jail time. I have to determine what's the appropriate sanction.
Okay, then the reason I have a huge issue with showing up at her house and thinking that the honking seatbelt rule, the text and seatbelt rule, is ever going to protect me is that man showed up at my house, broke the honking seatbelt rule, crawled up onto my porch and assaulted me on camera, and nothing was done to him. So you can see where I have a huge concern that when he breaks the honking seatbelt rule, gets to assault me, and doesn't have any consequences that you just mentioned, I'm having a huge issue with doing it again. Once shy, twice bitten. I am scared that man's going to assault me, and absolutely nothing's going to happen to him because it didn't happen the first time.
Well, and I don't know if you're referring to something that happened years ago.
He gave you his video.
Well, listen. The problem that arose in that entire scenario is the location where you lived, and apparently Chase was not coming out. We dealt with that issue.
She was standing on the porch, and that's why she was scared.
Well,
she saw
listen,
violence.
I saw what happened. The bottom line is, I get back to what I said earlier. If you want to do it, if you want to maintain that same protocol, then we put that in place. Otherwise, we're going to do the exchanges at a substation.
Substation.
Okay. So you need to determine what is the nearest substation.
Put in the court order the nearest, wherever it is, we'll find it.
So make that determination, and then you're going to do the exchanges at the regular time. What time are you doing?
5 o'clock Monday.
5 p.m.
5 p.m. on
5 p.m. on Monday.
Mm-hmm.
And so I'd like to start it immediately because Dad hasn't had Chase for some time. So I know it's Tuesday today. I'd like to do an exchange. Can you find a substation and communicate that by way of our family wizard?
For tonight?
For tonight?
Yeah.
Mr. Strange, is that okay?
We should be able to find the nearest substation. I mean, we'll just go on to Metro. They'll have the list of them.
Right. So that needs to be designated, and then that's where you're going to do the exchanges when school's not in session.
Thank you.
So that dispenses of the primary issue that was the reason the motion was filed. There are other aspects to this, though, I needed to address, and that was another reason I wanted to set this hearing, because I'm concerned about some of the representations that have been raised in the papers, most directly aimed at this court. And so I printed off copies of it's plaintiff's request permission to file for motion to modify exchange locations for the safety of the child and plaintiff. And again, we've addressed that issue. If you can give both parties copies And I know Mr. Strange is appearing by telephone, so so you can't see. This is just what the plaintiff had submitted, and the court granted, as a vexatious litigant, the court granted him permission to file the motion. But I wanted to cover.
I'm sorry, I didn't mean to interrupt you. I think it's attached to your order. Correct?
It is attached to my order, so you have a copy of this, but I just wanted to let you know I made copies and handed a copy to both the plaintiff and defendant. I previously swore both parties in. And so I want you to take a look at that. Plaintiff's request permission to file for motion to modify exchange locations for the safety of the child and plaintiff. Is that the motion that you filed?
Yes, ma'am. Oh, sir. Yes, Your Honor.
Did you prepare that?
Yes. Yeah, I'd like to apologize to the court. I am under therapy for post-traumatic stress disorder and depression. And when I wasn't able to see my daughter again, I literally had a meltdown, and I wrote this very angrily, very stressed, and very desperate. And the anger came out in my typings. And after I calmed down, I read my own thing, and I was actually horrified. I apologize.
Well, I appreciate that.
I
You
seriously
signed
flipped
this.
out again. My child was taken from me, and I flipped out.
Child was not taken from you. You did not exercise your custody time. That was your choice. You signed this.
I did.
Were the statements that you signed, were the factual statements in this motion true and correct?
To the best of my knowledge, yes, sir.
Okay.
Your Honor.
So I want to read some statements from here, and I want to ask you, because these are factual averments you're making about me, not just about this case. On page 8, line 18, you state, what's introduced by, what did Judge Duckworth do? And then the response is, changed custody based on the lies told by his old law clerk with no evidence.
Yes.
What do you base that on?
I was told that Michael Strange was your old law clerk.
And who told you that?
The first lawyer I ever brought in here. The only lawyer I ever brought in here.
Mr. Stoffel.
What?
Jason Stoffel?
No, that doesn't sound right.
He
He's a
previously.
young guy, tall, thin. He came in an unbundled capacity.
You did have Mr. Zernich at one
Zernich.
Oh, Mr. Zernich.
Jerry Zernich
Okay.
said that Michael Strange was your old
All right,
law clerk.
Mr. Strange, did you ever serve at the family courts as a law clerk?
I did, Your Honor, for Judge Ritchie.
Okay, and what years were you working as a law clerk here?
From August 2004 until March of 2006, Your Honor.
Okay. And did you ever serve as a law clerk after that?
No, Your Honor.
Well, it's interesting because I took the bench in 2009, so it's impossible for Mr. Strange to have worked as my law clerk since he was not even here. I was not even here when he served here. Okay?
He's never been your law clerk, ever?
Ever.
Then I apologize.
Okay. What do I do about factual statements? You know, it's one thing for this
The
court.
above statement is fact.
Listen, you can argue about and object to the decisions I've made, and I've told the two of you as parents, the litigation that's gone on this case has been extreme. And I've told you from day one, the first day I met you back in 2009, you know I gave you my counsel and advice that the two of you as parents need to resolve these issues for the benefit of your child.
Which is why I wanted to go to counseling.
Well, and at some point, and to be clear for the record, the two of you reached an agreement. You agreed to joint physical custody. Originally, you agreed that plaintiff would exercise sole legal custody. That was a point that was discussed and debated at length thereafter. In fact, at a hearing in 2012, I'd expressed my feelings about child support and legal custody. Both sides went out and actually discussed a resolution. You came back in, as you may recall. Mr. Strange reported that you'd reached an agreement. You were going to have joint legal custody. There would be no child support. Now, I made the mistake at that point that I didn't look at Mr. Plog and say, is that your agreement? to be clear for the record, Mr. Plug never voiced any objection to those terms that were placed on the record by Mr. Strange. Mr. Strange said it's going to be joint legal, no child support. I said, great, submit the paperwork, have Mr. Plug sign off, and we'll close the file. Ultimately, there was a motion for reconsideration. It was clarified for the court that I failed, and this goes to, again, this notion that you're unfamiliar with legal practices. You knew, you didn't voice an objection, and so I said, okay, you're right. It's still sole legal custody. Child support was reinstated, and we ultimately had a trial. And ultimately, we arrived at the point where the two of you are joint legal and joint physical custodians. But the inference here, it's one thing to criticize the court about decisions that have been made. But you cross the line when you suggest that there's any type of impropriety or unethical behavior by the trier of fact. Your implication here is that somehow this court is influenced based on a relationship that I have with counsel. That is non-existent. The suggestion is that this...
I was told that.
Well,
If
what...
there is a prior relationship that was supposed to be brought out in court, like disclosure or something, I was told that it's a law that if there is a relationship between a lawyer and a judge, that is supposed to be disclosed at the beginning of a court case.
And I have no problem with that.
And so that's when I brought it up. I brought it up on a lie by Gary, or a misunderstanding by Gary Zernich.
So what am I left with? You've impugned my character by suggesting that I have some nefarious relationship with counsel.
I honestly thought it was wrong. I thought it was wrong.
And it wasn't just there. On page 5, it was presented to family court by Michael Strange, allegedly Judge Duckworth's former paralegal, friend, fellow Liberal Party member, dinner guest, and church member. I have no idea what you're talking about. Again, you impugn the character of the court, because the bottom line is this court should not and cannot be influenced by anyone outside of what happens in this courtroom.
I agree.
Do you agree with that? Do you
totally
agree that no one should ever attempt to influence this court outside of what happens within these four walls?
I thought there was that kind of impropriety, influence, or whatever you call it.
Well, and that's the suggestion by what you're stating here,
Lawyer,
is that I've been
my own lawyer
influenced.
tells me something, I assume it's true. Why would they lie to me?
And you scatter it through these papers and then question why I've deemed you to be a vexatious litigant. The fact that Mr. Strange has never worked for me, he's never been my paralegal, never been my law clerk. The only occasions I recall ever seeing Mr. Strange are in this courtroom. I don't have dinner with Mr. Strange. I've never had dinner with Mr. Strange. I don't even know what religious denomination he is. The suggestion, I don't see him. He doesn't attend my congregation.
I apologize. I did not know.
Well, but it's strewn throughout your paperwork. And my point to you, because these are all falsehoods, and that's why I swore you in and said, under oath, are you declaring these facts to be true? Because, again, it's one thing to critique the court and disagree with my decisions. Believe me, in most cases, one or both parties leave unhappy because of something that's happened in court. This is not a happy place. It's a very divisive place, and we've had those conversations at length. And I try and be constructive. And what I've witnessed with Chase is very sad and unfortunate. But it doesn't end there as well. And you know you've submitted paperwork to the court where you made statements in a motion filed where you suggested to the court in a declaration that plaintiff represents that the minor child is seeing Jan O'Neill, a counselor. Mm-hmm. You told the court that a counselor was seeing your daughter and had opined, based upon her apparent professional experience and expertise, that she found sexual assault or that Chase perhaps had even been raped. Very serious accusations.
Mm-hmm.
And then I ultimately inquired of you. Ms. O'Neill
I didn't bring this to court.
Was she?
I was trying to get her to let me see.
Was she a counselor?
No.
No, she wasn't. You lied to the court.
I did.
And I basically said, look, if a counselor believes there's been any type of sexual misconduct, I said, I'm going to ask for the CPS reports because they're a mandatory reporter. So I guarantee you there's got to be CPS records. What did I find? No CPS records. What did I find out? Jan O'Neill is not a counselor, although you told the court in paperwork filed with me, you lied to me, and now you lie about my relationship with counsel. Counsel's doing his job. I have no connection whatsoever with counsel. And to impugn the character of this court goes beyond that line. And that's part and parcel of this entire process, Mr. Plog, as to why you've been found to be a vexatious litigant. You've been found to have submitted documents that have been doctored, documents that have been different for me from what the defendant has read. And you know, I know all of these things that a lot of other people don't know about you. And you come into court and you suggest that somehow I've got this relationship with counsel that is completely non-existent. And that crosses the line, and that's why you've been deemed to be a vexatious litigant, and you've got to stop this. This borders on perjury by suggesting I had a relationship, that he was my law clerk when I wasn't even on the bench. And so you take this information, you eat it up, and I'm sure you spew it out, and everyone thinks, whoa, wow, he's got this relationship with the attorney. It's ridiculous.
And I'd
it's
like
gotta
to give
stop.
a motion that'll get rid of all of this.
Well,
I'd like the motion that I give up 100% legal and physical custody of my daughter, and you'll never see me again.
and I don't believe that's in your daughter's best interest, and I'm not entertaining that oral request. The bottom line is
She made me an offer, and I'm accepting it. She
Well,
made that offer, and I accept it.
that's not before me, and
That's why I made a motion.
I'm not entertaining that.
I
When
literally
you
can't take court no more.
well, but when you submit papers like this to the court,
Freaking out, and I
well,
was
but that
desperate.
doesn't
I was
give.
depressed. PTSD is screaming at me, and I literally can't take this anymore. I'm suicidal. I would just rather see my daughter when she wants me to do it, whenever she wants me to do it, and never come back here again. And I don't have all this
Well,
stuff.
listen, you're here because you asked to be here. I granted your request.
Yes,
And part of
you
that
did.
was to work on the exchange protocol, but also part of it was to address, you don't have a license just to lie and spew this diatribe that you've acknowledged it's not true.
Correct.
And and I appreciate the fact that you've apologized for it, because somehow I've got to cure that. Because it's
My solution would do that. You would
Well-
never see me again.
I don't.
She's 12. I'll see her whenever she wants. 6 years from now, she'll be 18. We can do whatever we want. This solves your problem. This solves my problem.
Mr. Plog, you know and I know that that's not in Chase's best interest.
I didn't say I didn't want to see her. I just said I give up legal right. That means I can't file motions.
That's up to the two of you to enter into a written agreement and submit that to the court. That's not before me. You need to do that in writing.
And
My
let's go back
focus-
into a room and work that out right now.
My focus today was to address the exchange protocol that you raised in your motion. I said, let's set it for a hearing. But the other part of this was there was so much in that paperwork where you can disagree with my decisions, and that's fine. But the moment you cross that line and start attacking my ethics, I can't accept that. And that's another reason I wanted to have this hearing, to set the record straight when you start suggesting things that you know now are not true. Whoever told you that gave you some very bad information. And now it's in
Imagine my
paperwork.
feeling thinking that was true, going, well, my God, I got two friends working against me. I
This
felt
never-
helpless. And I don't have a lawyer because I can't afford one ever.
If that thought ever came up from the first time that Mr. Zernich made that statement, then why wasn't it asked? No one ever asked. You put the dates together, you know it can't be true. Mr. Strange could not have been my law clerk because
I know
I
that.
wasn't even on the bench when he worked here.
Now you told me, I apologize. And I apologize to Mr. Strange. I did not know that. I did not know that.
Well, I appreciate the apology, and that does go a long way. But you must be careful when you make those type of factual suggestions about the court in your paperwork. I've made my rulings as it relates to the exchange protocol. I would encourage you to find that police substation, to set up the time to have that exchange so that Chase spends valuable quality time with her father, because she needs that. You're both back on our family wizard. So I expect that there's going to be an exchange tonight at 5. If you have agreements that you've talked about through our family wizard, that's up to the two of you. That's not before me. It still remains my desire to build Chase's relationship with both of you.
And how about counseling?
For Chase?
All of us.
Well, I know we've broached that subject before.
We walked in and sat at the same table holding hands. It
I
does
know.
work.
I remember those days.
I
I
bet
do.
nobody else has ever done that to you.
I remember the day you reported back from the co-parenting class and what value that was. Listen, there have been those moments in this case.
Do it again.
I cannot. But the problem is, although I agree that Chase would probably benefit from some counseling, and I certainly would encourage the parties to communicate about having her just see someone just to voice where she's at. She needs an outlet. With everything that's gone on with the adults around her, she needs an outlet. And I think she's somewhat stuck in the middle. But in terms of family counseling, I'm not comfortable putting the three of you
Well,
together.
not family counseling, co-parenting.
Well,
Just us
yeah.
two. The problem children.
Well, I'm not inclined to go down that path because I just don't think you're both at that level. But as far as Chase receiving counseling, absolutely. I think she would benefit. And so you need to communicate about selecting someone that she can just, not for court purposes, just to help this little girl out. I've told you before, I'm watching this little girl grow up. She's 12 now, right?
In September.
12 in
she'll be
September.
yes.
And when this case started, she was 4.
Or 3.5, yeah.
And my heart goes out to her.
Well, in what you said about an outlet, in the last 6 weeks, my daughter has not been able to call me from her mother's house. She is restricted from calling her. She didn't even call me for Father's Day. So I would like her to have the ability to pick up the phone and call me. Or me pick up the phone and call her. Or text her, good night, Daddy, good night, Chase. I would like that ability, because in 6 weeks she's forbidden from calling her dad or even talking about him at the house. I think an outlet would simply be she has the ability to text Daddy.
Well, I have no problem ordering that Chase should be have the freedom to reach out and contact either parent.
Thank you.
There should be no restrictions. I get the fact that, listen, it can't dominate time. It can't. We're not talking about consuming hours of time, but brief, 15-minute. I'm not going to set up an exact time because that becomes a little too arbitrary. But Chase should have the freedom to reach out and communicate with the other parent. Okay?
And the one time I had her cell phone at her mom's house, she confiscated it. Can it be court ordered that my daughter gets to keep her cell phone in her room and has freedom to text back and forth without the phone being confiscated?
Let me hear from Mr. Strange.
I think the court latched on to my concern is, one, it isn't forbidden, so that's just not true. But the concern as well is that, I don't think this should be to where it dominates, where, there shouldn't be 500 texts going back and forth on, my client's time. They may have activities planned and other stuff, just as I'm sure the plaintiff has activities planned when he has a child. So I don't think my client, I know I'm not there, doesn't have an objection to that order, but I think it should be, in that order that it shouldn't be overwhelming and dominating.
There should be a reasonableness to this. Like I said, what I don't want to see, what I don't envision is the constant texting throughout the day.
I wouldn't abuse it.
And that it goes on both ways, because that's your time. But in terms of having one Skype or FaceTime visit occasionally, I'm not even saying it has to happen every day, but I'm not setting a specific protocol in terms of when it has to happen. My only order is that Chase is given the freedom to communicate with the other parent within reason, and I'm not going to necessarily define exactly. If it gets abused, then I may see again. But
Be abused.
listen, give.
And it is, what he said is not true. My daughter hasn't contacted me in 6 weeks because she's not allowed to. She didn't even call me on Father's Day. So yes, she is restricted from calling me right now. That is true.
She needs to have that freedom. And again, as I've indicated earlier, my understanding is it's not as though there's been a withholding of custody. It's been a decision that the plaintiff has made not to exercise his time. It's unfortunate. I'm hearing about Father's Day. The one day out of the year that Chase should be with her father is Father's Day, and vice versa on Mother's Day. But what the sense I'm getting is that wasn't necessarily the defendant's fault. you didn't exercise your time. So go exercise your
me.
time. You're going to do an exchange today at 5. Find the nearest police substation. Do we need an order prepared from today, or will the minutes suffice?
Probably in order, Your Honor. And then I do have two just clarifications. Is that for today it's the exchange on Tuesday, but then the following week would be back to the regular Monday.
We do Monday. Yeah.
That's
Yeah.
fine.
Okay.
And then just, I know my client had another motion. Is the court in terms, I think it was an NRCP 11.
Yeah. I'm just not inclined. I think it related to an offer that had been made that the plaintiff made representations that he was on our Family Wizard when clearly his subscription had expired and he was not. I could not find. I could not find where that representation was made that he was on our Family Wizard. I looked through the motions again, and maybe I just missed it. Can you direct me to a specific location?
No, I never intimated that I was on Family Wizard.
Your Honor, on his ex parte request that he submitted to the court, page 15, below, or I'm sorry, a couple of lines above his signature, specifically line 11, it states, note, plaintiff did send a request to defendant to switch custody. Defendant refused on our Family Wizard on June 4th, 2017.
Yeah, that doesn't say that. Let me read it. Plaintiff did send a request. There's the letter.
Okay. And then you're
And the
saying that,
defendant answered on our Family Wizard because she knows I can't get on it.
okay, but now you're on it.
I'm on it now, yes.
But it didn't. So I think what I'm hearing is plaintiff did make a request, but he did not suggest that he made it through our Family Wizard. He made a request
It was
independently
off
through
since
letter.
April.
So I'm not inclined to entertain any other relief. Like I said, my primary purpose today was to talk about the exchange protocol. We've tweaked it a bit, but also to address some very serious factual misstatements that the plaintiff has acknowledged were incorrect and has apologized for that. So the court recognizes that. So if you'll submit an order, counsel, if you'll prepare and submit to Mr. Plog for a review and signature. And Mr. Plog will have 10 days to sign off. What's that?
Yes, Your Honor. That's what I was about to ask.
Okay. All right. Thank you for your appearances.
Thank you, Your Honor.